And we have a few items. I looked through, and it seems like 1 through 7. I reviewed those minutes and assessor approved process reports. Do we want to hold any of those for discussion, or can we?
I don't need to.
So we have a motion. Well, suspend the rules so that I can have a second for now, at least.
I'll make a motion that we approve items number 1 through 7 on our regular agenda.
All in favor, say aye.
Aye.
Aye. That passes 2-0. We have number 8, approve assessor's primary residential exemption changes approval report. I've gone through the 89 records. Are there any comments? I have none myself.
I'll make a motion that we approve them.
All in favor, say aye.
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 Oh, did you want a second?
It's a habit of mine, so I'll second. All in favor, say aye.
Aye.
Aye. That passes 2-0. Number 9, approve or deny the reinstatement of the primary residential exemption on the parcels listed in the attached spreadsheet for the year 2022. And I've gone through those as well. I don't have anything that stands out to me.
Well, if they want to reinstate them into primary residential, I'm fine with that.
I am too. I have a motion on that.
Make a motion that we approve.
I can second that.
Let's see. Oh, I forgot the number.
It's number 9.
Number 9.
Yeah. I can second that. All in favor, say aye.
Aye.
Aye. That passes 2-0. We have number 10, approve or deny profit exemption application for the Heritage Behavioral Health System. And they have been in operation since January 5, 1998. Is there anyone here to speak to that?
Commissioners, I've just been communicating with Vicki over Teams. We're not totally sure that we may have properly noticed both the organizations at number 9 and number 10 and 11. It might be wise to continue those for 1 month so we can ensure that proper
just 10
notice
and
is
11.
given.
Okay.
So continue number 10 and number 11 1 month.
Yeah, the 2 exemptions, we can continue this for a month. That's
Okay.
not going to impact
Once-
that. And then it would give us a chance to make sure they are properly noticed and so they can come and present before the board.
Okay, as a point of reference, number 11, it says it's charitable, but to me, as I read through it all, it seems to be educational. So when you follow up with them, would you let them know that?
Number 10?
And number 11.
Number 11, there's probably going to need to be some significant discussion. We probably should just
Okay.
not worry about that until next
Okay.
month.
I'll make a motion that we continue items number 10 and 11 for 1 month.
I can second that. All in favor, all in
Aye.
favor, say aye. Aye, that passes 2-0 for number 10, 11 to continue 1 month. You know what? Do you mind if we skip down to number 15 and we'll come back to 12, 13, 14? We have the owners of the David Bagley Revocable Trust with
Is
us.
Amelia on?
Commissioner Lee, that's a good point. Commissioner Gardner, are you here yet?
Let me check. I don't see her yet. Yes, here. Let me promote her to panelist.
Commissioner Gardner, can you hear us?
I can. I was there, but I wasn't a panelist, so I was just listening to y'all vote. But I didn't disagree with any of your votes, so we're good.
Okay, good. So from this point forward, will be 3 commissioners participating in this meeting. We've jumped to item number 15, which is to approve or deny application for the Stewart David Bagley Living Revocable Trust, which is the bee farm. From my part, I went through the additional documents, and I think he has some additional material that he wanted to share with us. Go ahead and bring that up. But the ones that have already been provided to us previously, do you have anything else you want to give us?
Yes, sir. I've contacted the Utah Department of Agriculture and Food, and Jenna Crowder, she's a diagnostic entomologist. She has written this letter supporting us.
I'll take one more for her when she's back. And thank you. They stick for a long time. Let's see, I'm reading the letter now.
Yep.
I'll take a picture and send this to Commissioner Gardner while She's on phone, so at least she can have this document. I'll give her the hard copy when I get back to the office.
And your name?
Stuart, David Bagley.
Okay.
And I went through, and so there's the history of, earlier there was a conflict because one was saying that it appeared to be sustainable as a farm. The other one said it was not, that 50 colonies wasn't sufficient for the acreage it had. But the additional documentation he gave us since that time is that he's gone, did I read it right? 289 colonies?
Correct.
And then there was 129 colonies, and it dropped because seasonal effects happened. But
Yeah, the colony collapse disorder, yeah.
so you've had a up and down cycle, which is not unusual for any farm of any construct. Do we have any questions beyond that?
I don't have any questions. I do. I mean, I appreciate this letter, and I'm actually fully in support of this staying on Greenbelt status. Just so you know, I think I stated that the first time. I think it's problematic. There's some problems, and it's problematic, and so I would, well, maybe I'll listen to any if there's any other concerns in there, but I'd like to explore with you some solutions.
Okay.
But I don't know if there's other commissioners that have other questions that might pertain to it.
Okay.
I don't have any additional because the materials seem to substantiate, and this also helps. Go ahead if you.
Commissioner Gardner, do you have any other questions?
No. I've been pretty steady on this. I know that if you looked at all of the requirements, they didn't necessarily meet every one of the requirements, but they met a substantial number of them. And the way I read the law was not an and, it was an or. And the fact that they met several of them, I have felt that they should stay on Greenbelt the whole time. So, and in fact, that the letter that was just sent and the explanation of, this is the lowest number of beehives they've had. It goes up and down. I mean, I think all of those things substantiate what my original thought on this was. So I'm happy and ready to vote.
Okay, I have maybe to help you navigate through this process just a little bit.
Okay.
And give you some of my perspective, and then I want to give you as much latitude as possible from my perspective on what you would like to do. This is your lawyer, right?
That's correct,
Okay,
yes.
all right. It's good to have you.
I apologize. I was doing a court hearing by WebEx out in the parking lot, so.
No, it's good to have you here. And so I'm wondering. I want to give you some options. If it's approved. If it's approved today in the Board of Equalization, you will, or the assessor's office will have the opportunity to appeal that to the state, and then you'll have to go through go before the state, right?
Okay.
And fight that out there. I have no idea what that's going to look like or what that might look like. I would anticipate that you probably have maybe a 50-50, maybe less than a 50-50 chance of winning there at the state. It might be less than a 50-50 chance just on some of the records that I've read on that. So I don't know. I don't know what that would look like. If the Board of Equalization here denied your request, and then gave you a form, and we call it the 1347. Because we have to function within a certain box, to work within a certain box parameters that we have here. If the Board of Equalization here denied that request and then had you fill out a 1347 application with the county, you would have the ability to come before the commissioners, which is again all three of us. And in that meeting, we have greater flexibility to do some things, and so. With that greater flexibility, we could look at it and try to find a balance in there that might be more favorable, or it might not. I'm just kind of giving you the lay of the land with what could happen there. But I have found that usually the commissioners have been very favorable, for some of those conditions, even over and above what we see in the Board of Equalization. And so I want to give you those two opportunities. I couldn't speak to you before this meeting, and I wouldn't be able to speak with you after this meeting because Paul would say that's ex parte communications. But during this meeting, with everyone present, I want to give you those options to kind of ferret out and see what would be your best option. So I'm not sure which way you would like to go, but I'm sensitive to that. At least for my vote, I can only speak for one vote, but I want to kind of give you that option.
Okay.
Has the assessor seen this letter that you just gave us?
My only concern with
I
that
just turned it
path
over.
is that even if we abate the rollback, they're still not on Greenbelt moving forward. Right? So my only concern with us denying here and then abating, like, yes, they won't have to pay the rollback tax, but they're still going to be taxed moving forward as a non-farming parcel. Is that correct?
Well, that's correct, unless they go through a process to, to make sure that they have production, and I don't even know where that would go if there was a challenge to that. Where would that challenge go if it was denied again on coming, like we've done in the past? Where would that challenge go?
If they apply for Greenbelt and they're denied, saying that they don't meet production requirements, that can also be appealed to the state tax commission, I believe. It can be appealed here and then appealed to the state tax commission. I mean, they can apply for Greenbelt, get denied in their application process, appeal that decision to the Board of Equalization, and then move on in the process. So not just appealing a rollback, but actually appealing a denial to be put on Greenbelt.
Yeah. Yeah, so it would be a kind of so. But of course, the commissioners could adjust, modify anything when it comes to the taxes on that. But the Greenbelt status itself, which is what's in question right now, could still go through that process where it would be either approved or denied based off of the last 2 years.
Yes.
Have you seen this letter, Bert?
I have
Paul?
not, no.
Because the second half, maybe you should read it. That'll help add some light to it.
So I guess in what they're saying on that, to maybe just kind of clarify it a little bit. If it was denied here, and then and let's just make some assumptions that you went through the 1347 application, it came before the county commissioners. The county commissioners looked at it and agreed that it probably needs to stay on Greenbelt. We'd probably put some stipulations on there saying that if it went through the Greenbelt review process and was put back on Greenbelt, then we'd continue the Greenbelt status and move forward. And in that meeting, some things could be adjusted, maybe even on the tax basis. There could be some conditions put on there that if it went through that process and was denied all the way through to the state, it'd be kind of interesting because, well, we'd have to approve it and then it would be challenged possibly back to the state on that. There would be, there's options. Or if it was approved here, then you could just take it straight to the state. But what would be tagged with it would be also the 5-year rollback if it went straight to the state, because the state would then say yes or no to the status, which would make the Greenbelt rollback enforced or not. Those are kind of the two options.
Hey, I'm at a disadvantage because I walked in when things had already started. Did you guys go over the correspondent, or did you see the correspondence we submitted from Sterling Reese from the USDA? It was emailed to your office. over a
I've
week
got
ago.
the attachments that were submitted on the history.
I'm just looking at the,
If I may approach, this was emailed to your office.
oh, the tax commission,
Okay,
that email? No?
There's a September 29,
Yeah, sure, sure.
2022, which is an attachment.
On the agenda items, Commissioner, that's labeled under
Oh,
the
that's it.
documents is 10-13-2022
Oh, okay.
USDA letter Bagley.
Okay, yeah, we got that. We got
Yep.
that document. I didn't know which one you're talking about.
because this letter kind of is in conflict with the letter submitted by the state of Utah. This was written by Sterling Reese, dated October 13th. He works for the USDA. It's his job to track honey production as well as number of hives, colony collapse, etc. But like on the fourth paragraph down, he says for optimum pollination and production, beekeepers set out 2 to 10 colonies per acre. This ensures a healthy environment for the bees and excellent spacing for pollination. And so that is what Mr. Bagley has been doing. And then down at the bottom, there's a paragraph that says on any given year, Bagleys and other beekeepers can suffer 65 to 85% losses to bee colonies due to colony collapse disorder, and average losses to beekeepers nationwide is around 50%. However, the letter that was submitted by the state of Utah, he indicates, okay, Brady Kelsey from the Utah State Tax Commission, he says, well, the regulations are vague, and they're vague, we don't really like them. So he contacted beekeepers in southern Utah, and what they came up with, they're saying they staged 1,200 to 2,000 colonies at one place. That doesn't jive with what Mr. Rees from the USDA has indicated. And Mr. Kelsey from the State Tax Commission says that he's being reported only 1 to 5% of the colonies die from fighting. At the first hearing that we had in August, we had Dan Bagley. He's sitting right here. He's Mr. Stewart's dad. He has been actively, consistently, at all times involved in the beekeeping business for over 60 years. Their family business of 130 years has always rotated, and they haven't had their hives, they haven't put them all together at one place. They're constantly rotating them because the bees fight, and it makes for healthier, happier bees when they're not stuck together. And then there's a lot of fighting between the bees, and so this is how they've done it. This is what's worked for them. But the thing that's frustrating is Brady Kelsey, he's not an expert at honeybees. He had to call somebody down in southern Utah to figure out really what's appropriate, what the industry standards are. And he's saying, well, some beekeeper, we don't know who it is. Somebody down in southern Utah told him this, but we couldn't follow up. We couldn't find out. And he's being reported only 1 to 5% death rate. But we have the USDA. This is his job. He knows what he's doing. He's saying, yeah, it's real that they put 2 to 10 colonies per acre. And so I believe just with the letter submitted by Sterling Reese, it's sufficient to grant Mr. Bagley's appeal.
So I agree with what you're saying. I just, in the sense of what the bees are, to the agricultural production. And I don't think that's the issue. The issue is where do you want to fight this thing? Do you want to fight this thing with the greenbelt status attached to it at the state level? Or do you want to come back to the commissioners and see if we can send it just on the greenbelt status without the 5-year rollback necessarily attached to it to the state? Which route do you want to go to fight? Because it looks like this is going to go on and eventually have to be determined by the state.
Okay, so has the state indicated that if we're successful today, they will appeal it?
Well, it's not the state; it would be the assessor's
Our
office.
assessor's
I'm just
office,
going
excuse
off the assumption that they would.
Have they indicated that they?
Well, I don't think they've seen these two documents yet either, so that might change some
Well,
thoughts on
we
the
can ask
assessor's side.
Diana if she would appeal it.
Oh, here.
I mean, this is
This
this is not an ex parte now. We're in an open and public meeting looking
Yeah.
at Paul. So we can ask that question if she's willing to.
And do you have the other one too? There was two of them. One,
Okay, let me find. Okay.
Because if it's appealed and the
then this
assessor's
one.
office doesn't, I mean, if it's approved and the assessor's office doesn't appeal it, then it's done. It's over and done.
And Stanley County Attorney's Office. The assessor isn't here personally, doesn't have an obligation to explain his intention based on how this might go. But my impression is that there's reason to go to the state. We have the letter from the State Tax Commission's auditor saying that they see 20 to 50 colonies as sufficient to support 1 acre in greenbelt status, that they typically expect to see greenbelt with beekeeping as a secondary or tertiary basis for it rather than the primary or exclusive means of satisfying a greenbelt status. And so the concern from the assessor's office, of course, is that if it's too easy, if you can put two hives on an acre and qualify it as greenbelt, everybody in the county will want to get qualified through beekeeping rather than through the kinds of production that would satisfy the standards as required. So there's two different things that the Farmland Assessment Act expects. It expects a reasonable expectation of profit. We don't dispute that. We know that this is a legitimate business. We think that the bees are wonderful, they're valuable for agriculture, but then there's also this active devotion to agricultural production that is measured by quantifiable production, and it has to satisfy the standards that the tax commission promulgates. Their standards aren't great on beekeeping, but we've got the letter from the auditor saying that they're expecting about 50 hives per acre, and here we have 50 hives, 20 to 50 hives total to try to qualify 6 acres. So from the assessor's position, it's hard to say that it's, I wouldn't say that it's unlikely that it gets appealed. It seems like one that would be likely to be appealed.
and the assessor has both of these documents?
We have not seen these letters, but again, these letters speak to, I mean, we saw this one today, but it speaks to the same point that I just made. We don't dispute that there's a reasonable expectation of profit here. We don't dispute that this is a legitimate licensed business. What we question is whether it's sufficient. And here, even Jenna Crowder is saying 50% production requirement would be met by supporting the 20 to 50 hives per acre. Here we have 20 to 50 hives total.
But
And
that's
so
that's just here and now. They've had as many as 289 hives.
Right, but our question that we have to look by statute at the last 2 years prior to the Greenbelt application. And so in the most recent 2 years, we haven't seen sufficient hives to be the sole basis for a Greenbelt designation from the assessor's view.
I think 289 was in 2019. I don't remember what they had in 2020. But regardless.
Yeah, I mean, we're looking to see, I mean, really, ideally, and historically, this parcel had grazing as well, and so the beekeeping was not the primary basis, the production there. So what the assessor's office is looking at is, are we being fair to all taxpayers? Are we being reasonable? Are we showing the kinds of production that would meet an annual units per month measurement? The standards aren't as good with bees as they are with other large livestock and other kinds of grains and fruits and flowers and whatnot. But with beekeeping, we do have the guidance from the auditor for the tax commission saying that he expects to see 50 hives per acre and that he thinks that would be a fair utilization and that less than that's an underutilization. So that's the way the assessor's office is looking at it.
And that takes into account the collapse of hives that happen.
Yes, and that his analysis is based, as counsel for the taxpayer indicated, on some conversations with beekeepers in southern Utah and the research that they've done, and they've looked at some numbers of fighting and disease that can spread in hives. They're trying not to make it they're trying to be generous, but it's a standard that hasn't been met in this case. And so that's what the assessor's looking at as kind of the objective way to measure that second prong. We see a reasonable expectation of profit, no question. But on production, we see that there's an insufficient amount for what we think the tax commission is looking for.
So with that, I would say that it's probably likely that if we were to approve of this, that it'd get appealed to the state. And so again, It just kind of depends from my perspective on where you'd like to, and where and how you'd like to fight.
And maybe I'm not understanding this, but we're going by the state tax commission's own standards that specifically says a few honeybee scenarios may qualify land for FAA assessment. For example, an apiary or bee yard used for staging or wintering a large number of beehives may fully utilize the 5-acre minimum requirement. Mr. Bagley's complied with the Utah State Tax Commission standards. They're the ones that adopted them. And it's frustrating because the State Tax Commission, this gentleman, Brady Kelsey, he's saying one thing that's not realistic. It's not realistic. We have the USDA saying something totally different, and the USDA is somebody who it's his job to monitor bees, the number of hives, colonies, honey production. And he had to call somebody. We don't even know who he called. I think the commission needs to follow this. It's just frustrating because they're saying that it's vague, but it's not our fault that it's vague. And their colony collapse is real. There've always been more, but the colonies are totally collapsing. Mr. Bagley's doing his best to get his colonies up, but he has to work with what he has to work with.
So you would be in favor of us approving this here in this meeting?
And then, what, do an appeal?
Now, you wouldn't appeal, you wouldn't. More
The
than
state
likely,
would,
the
the assessor would.
assessors would appeal to the state, and that's that one choice.
Yeah.
The second choice would be for us to deny it here. You take it to the Board of County Commissioners. So I'll try to be as precise as I can with it. If it's approved here, like what was stated, more than likely it'll be appealed, and it will be appealed to the state as on a greenbelt status, and the rollback tax will be intact. So they'll go together to the state. If the state turns around and says, we agree with you on this, then you stay in greenbelt, and you stay in greenbelt. If they disagree and they on the appeal, if they agree with the appeal, then what happens is you pay the 5-year rollback tax, and you're not on greenbelt. That's one path. The other path is possibly, and I'll put it as a possibly, that you fill out the 1347 application. The 1347 application comes back before the county commissioners, and then the county commissioners have a couple of options. We can say, on a tax basis, this rollback tax basis, we can maneuver it back and forth. We could eliminate it. We could say we're going to do parts of it. We can modify it. We can change it. We can put you into a payment plan, or we can put you with some options. For instance, you'll probably have to go to, if we deny it, then it comes here, but you're not on greenbelt. And that's the thing. So you fill out a greenbelt application to prove your 2 years that you're in production. And if that gets denied, then your application comes back to the Board of County Commissioners. It'd probably eventually go to the state again. Now you're arguing, it doesn't go together. It doesn't necessarily go together. You don't have the greenbelt tied with the rollback tied with the greenbelt. Now you're taking the greenbelt only to the state, unless there's a tie from the county commissioners on what that looks like, determined from the state itself. So that's kind of the scenarios that are possible out there.
I believe, and I'll check with Mr. Bagley, we would just like you guys to approve it if you're willing to, and take our chances with the state of Utah.
Fair enough. I'll make a motion then that we approve item number 15 on our regular agenda.
Is there a second?
I'll second that motion.
All in favor, say aye.
Aye?
Aye.
Aye.
That passes 3-0.
Okay.
Thank you.
Thank you. Sorry for being late.
No, fine.
Okay. Now we'll go back up to item number 12. Approve or deny petition to hear appeal of property valuation for parcel 0006.
So this is the appellant in their petition stated that they were basically not paying attention. They've been out of the country on a mission and were not paying attention to the deadline and did not file on time. I might be simplifying that statement, but that's basically
That's why I
yeah.
caught it, yeah.
Did this one come before us before? Is this a
No,
continuance?
we've seen these before
I
where
think I think we approved them before, right? Where they were saying they're out of the country.
no, we have these all we have these frequently where someone is out of the country on a mission or
Yeah.
or out of the state on a
Business,
mission.
whatever.
I honestly, off the top of my head, don't remember what the board has decided in the past. I think it's been kind of depending on what they put in and whether or not it's approved or not.
Seemed to me like we approved the last ones, and
Yeah.
I feel inclined to do the same.
I'm
on this one.
inclined to support
Okay.
this appeal. Do we have a motion? Or I should ask, do we have any comments from you, Commissioner Gardner?
No.
Okay.
I'm ready for the motion.
I'll make a motion that we approve item number 12 on our agenda.
Is there
I'll second that motion.
all in favor, say aye.
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 Passes 3-0. Number 12, approve or deny petition of property valuation for parcel 0071.
This is 13, right?
Yes, appeal number 1334, 2022. And this person was out of country for a family emergency, and they missed the information, or they missed filing.
Yeah, so this appeal was filed by a tax appeal representative. The representative, because the owner was out of the country, was not able to file the appeal timely. They had to wait on the owner to get them back the documentation. So I mean, they didn't really kind of go into more detail about what the family emergency was, but it should be noted, and I kind of noted this in my comments, that this is a commercial appeal. So where this is for business, I have to wonder why there was no. If the owner was out of the country, usually with businesses, other corporate officers can act for the owner.
CPA or
Someone had to be
somebody.
running the business while they were gone. It does state in the standards that it should be that no other owner or individual was able to file the appeal on time. So, but again, I think we tend to lean to give folks greater latitude in these circumstances when it seems like there could be a good reason for not filing timely. So I would defer to the wisdom of the board on this one. As per usual.
I'll make a motion that we approve agenda item number 13.
I'll second that motion.
All in favor, say aye.
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 Aye, that passes 3-0. Number 14, approve or deny a hear of property valuation after filing a deadline on appeal number 1335, 2022. And this was also another emergency that came up and happened during the month of March of this year and missed the valuation that was submitted.
Yeah, again, this they're staying back to the fact that there was a death in the family. The death in the family happened back in March. I mean, obviously, a death in the family would be a significant event, but the person passed away in March. You've got a full 5 months before the filing deadline.
I get it.
I mean, everyone handles a significant event like that differently. I mean, I could see, someone being very distracted for a long time.
Yeah, it's the diagnosis of leukemia in December 2020, and they were focused on it until his death in March 2022.
Yeah. And it's also worthy to note. It's also worthwhile to note that the property owner has filed an appeal previously in 16, 17, and 18. So I mean, they have previous experience in filing appeals.
Were they successful?
I don't remember. I'd have to look at the appeals. I'd have to look at the details. I can if you would like to
No,
give me a moment to do that.
It's just curious.
You always ask me a question, Commissioner, I'm not prepared for. Good job.
Well, these are to hear an appeal, right? Approve or deny.
Yeah, you're just-
so
you're just-
so all we're doing is just giving them an opportunity to state
Right.
their case, and so I'm very sympathetic to that. I'm ready for a motion unless there's more comment.
Commissioner Gardner, do you have any additional thoughts that you would like to share? Commissioner Gardner, do you have any thoughts that you would like to add? She may have.
Nope, I'm good.
I'll make a motion to approve agenda item number 14.
We have a second.
I'll second that motion.
All in favor, say aye.
Aye.
Aye, that passes 3-0.
Before the board moves to adjourn, as we're done with the agenda, Vicky pointed out, is letting us know that a representative from the Libertas Institute has joined the call. That was specifically item number,
That was
10.
11.
sorry, 11. That was item number 11, which the board has already continued until the next month.
Should we
I
just
don't know what the process would be to discontinue it,
Should
or
we
if they would.
modify the motion and the vote in this setting? Council?
Yeah, if we've got someone here to present on it, I think we should let them present now.
So should I make a motion to modify our vote?
I think you could just motion
Yeah, well,
to bring the item back on
Okay.
to today's agenda.
So we'll make a motion to bring the item back to today's meeting.
I'll make the motion to bring item number 11 back on to the regular agenda.
And I'll second that motion.
All in favor, say aye.
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 That passes 3-0, is now brought back. Item number 11, approve or deny tax exemption application for the Libertas Institute. Account and number last four is 4686.
And we have Vicky Westgard from our office, and I believe Adam Beck is here from the attorney's office to represent the auditor's office, and then Mr. Connor Boyack is here representing the Libertas Institute.
So would we like someone to speak to this, Vicky or Connor?
This is Vicki Westergaard, Clerk Auditor's Office. Adam, do you want to discuss what we were talking about earlier today? Adam?
Yes. Thank you, Vicki. Adam Beck, County Attorney's Office. We did have some concerns that this applicant would not be eligible for the charitable exemption. There's two items I wanted to touch on. In 59-2-1101, it talks about the definition of a charitable purpose. So in order for them to get that exemption, it has to be for a charitable purpose. And it has to be it has to be a gift to the community. In the property tax exemption standards of practice, it talks about what a gift to the community would be, and I'll list them off here. Lessens the burden on the government, providing a significant service to others without immediate expectation of material reward. The use of the property is supported to a material degree by donations and gifts, including volunteer service. The recipients of charitable activities that are provided on the property are not required to pay for the assistance received except to a material degree. The beneficiaries of the charitable activities on the property are unrestricted. If it is restricted, then the restriction bears a reasonable relationship to the charitable activity objectives. and any commercial activities provided on the property are subordinate or incidental to the charitable activities. And going through this application, we have not seen how this would be a gift to the community. It does not. We did not see that it lessens the burden on the government. And then additionally, in that same section, that's 59 to 1101, 6, it says a property may not receive an exemption under the charitable exemptions if the nonprofit entity that owns the property participates in or intervenes in any political campaigns on behalf of or in opposition to any candidate for public office, including the publishing or distribution of statements, or a substantial part of the activities of the nonprofit entity that owns the property consists of carrying on propaganda or otherwise attempting to influence legislation. And working with Vicky, per their annual report, it shows that 85% of their proposals become law. And it sounds like they're heavily involved in making proposals for legislation. And that was another concern that we felt like may prohibit this applicant from being eligible for the exemption. And Vicky, if there's anything else you'd like to add there.
Yes, I think what they do is good. I just wasn't sure whether it met the charitable purposes definition. So that's why I brought that up to Adam.
Okay, Mr. Boyack, it seemed like when I was reading, maybe it was an educational purpose, not charitable. What were your thoughts? You've been in operations, I think, since 2011. Have you always had a charitable exemption?
Hi there. Can you hear me okay?
I hear you fine, yes.
Excellent. My name is Connor Boyack. I'm president of Libertas Institute. Thanks for giving me some time. I got notice of this meeting 15 minutes after it began by Ms. Westergaard. I wasn't aware that such a meeting was taking place or that we needed to prepare anything in defense of our application. So what you're getting is a little bit off the cuff because I just showed up and here we are. In response to Mr. Beck's concerns, I would indicate that every single line that he read is exactly relevant to our organization. The fact that his characterization about a significant portion of our work is being taken from an annual report that he's misconstrued is a bit problematic. Yes, we do work with the legislature, as I think all the commissioners know, to propose legislation. That is not a material question as it pertains to this statute. The question is not whether we are successful when we do propose legislation. The question is, as Mr. Beck read, whether that constitutes a, quote, substantial part of the activities of the nonprofit. If our political activity did constitute a substantial part, we would lose our charitable exemption. We are, by IRS regulation, not allowed to engage in a substantial amount of political activity. Reading that single page from the annual report is not indicative of the overall many other activities that we do, which pale in comparison to the specific legislative proposals that we make. That constitutes an insubstantial portion of our work relative to everything else we do. Yes, we've been in operation since 2011. We've had an active, compliant, charitable exemption from the IRS for that entire time. There's never been any issue with that. We've been fully compliant in review and audit ever since that time. The initial definition that was read regarding a gift to the community, I might snidely suggest that our work very much involves lessening government's burden although I don't think that's what that particular provision was meaning to imply. But the second definition, the A through E, definitely relates, I would argue, to what our organization does. We provide significant service to many others in a variety of aspects of our work. We're supported by donations and gifts, including volunteers. They are not required to pay for the assistance they receive. These are unrestricted gifts, and that the commercial activities are subordinate or incidental to the charitable activities that we engage with this property. So it sounds like this is a high-level reaction to what Mr. Beck or Ms. Westergaard perceive us to do. We've not been interviewed. No one's come to look at the full breadth of our activities. No one's been reviewing the 990s, it looks like. And so these reactions that have been expressed sound like a fairly uninformed review, if we can even call it that, of what our work does. We believe, and the reason we put in the application, I assumed this was all automatic until we got a notice in the mail that we owed this tax, and I guess we were under the mistaken assumption that we had already either applied or automatically been granted this as a condition of being a charitable organization. But we're very confident in our position. The concerns expressed are really incorrect characterizations of our work, and I would ask the Commission's support or approval of this exemption request.
Just a quick note, Commissioner, Mr. Boyack said that the notice situation was problematic, and because of that, if he wants a continuance, I suppose the board would readily grant one if he needed more time or if he wanted more time to prepare for the meeting.
I'm fine to move forward, but thank you.
Commissioners, there is a question. This organization has been in business for many years, and they did not apply by the March 1st deadline. So if you want to, take that into consideration, whether or not to approve them for next year or have them turn in a continued statement for next year, because they did apply late.
The application, I think it was signed August 16th this year.
Yes.
Okay.
Okay, just to clarify, Vicki, could you please clarify that again? And Mr. Boyack, could you also maybe clarify the only allowance for an organization to apply after the March 1st deadline is if they are applying for newly acquired property within 30 days of acquisition. Is the property in question here new, or is this for an existing account or existing property?
It's for an existing account.
Okay, so has this account been in existence for multiple years? Not just this year then?
I think 2000.
Let me check on that real quick.
The reason that's an important clarification, we talked about this in our prior meeting, that while the state legislature has extended the ability for an organization to file later, but that law will come into existence starting on January 1 of next year. The current statute only allows for an organization to file after March 1st within 30 days of acquisition of new property. Now, if it's for an existing account in which they're applying for an exemption for the first time, the deadline is March 1st, and there is no provision to file late currently under current statute. We have changed that starting next year, where we can consider a late application up to 60 days after March 1st with extenuating circumstances. But really, if this is for an existing account, it probably shouldn't have been brought before the board at all, because I don't believe this can be filed. I don't believe this can be filed late, regardless of whether the applicant actually qualifies for the exemption or not. It's past the deadline.
Bert, I looked online, and it looks like the personal property people created the account in July of this year.
Okay, so they applied. So
Apparently, they did not have one previously.
okay, so it was. So this does meet the 30-day deadline. Excellent. Thank you.
Okay, so it is a proper within order because it is a new account, correct?
It is. It was.
Correct.
It was timely filed, Commissioner. Correct.
Okay.
Okay. From my standpoint, being someone who's more familiar with the organization than our attorney's office is, I recognize the extensive charitable donations of the organization. Everything from helping students obtain, special needs students obtain scholarships, to helping medical cannabis patients not be discriminated against by the government for their medical cannabis use, all the way to small business owners who are shut down by regulation, who this organization helps assist free of charge with no expectation of return. I definitely see that they have an immense amount of charitable good that they do, not to mention all the educational programs that they put on regularly for members of the public at no cost. So I feel completely comfortable moving to approve this application. So I'll let the other commissioners speak, but when you're ready, I can make that motion.
So Adam, I wanted to touch a little bit on the political activity, because there's a lot of charitable organizations out there that engage in political activity, even some of our religious organizations and our hospitals that are heavily involved in political activity. See them up there on Capitol Hill on a regular basis, and they're highly successful in how they accomplish, some of that political activity. So when you mentioned that, I was trying to justify where that was coming from on a political side.
Well, and as I mentioned at the beginning, these were concerns. We only get a limited glimpse at the organization through their application. We try to dig around and find some as much as we can, but as it does say, it needs to be a substantial part of the nonprofit activity. And what we saw, it looked like they may be doing a lot of it. And that's what this venue is for. Is for both parties to come and present their evidence to you and have you make that determination. But that was one of our concerns, was that they're involved in this legislation, and if it is a substantial part, then yeah, we do have a concern that they may not be eligible for the exemption.
Okay. I just never heard that before. There's been organizations before us that are heavily political, and so it was not one that I had read in the standards as something of major concern or consideration. But so I just thank you for that explanation of that. I'm ready.
I have no additional comments to make. Ready for a motion?
All right, I'll make a motion that we approve item number 11.
I'll second.
All in favor, say aye.
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 Aye, that passes 3-0. As approved.
Thank you, Commissioners.
As approved. Thank you.
I'll make a motion that we adjourn.
I'll second that motion.
All in favor? We are
Aye.
adjourned. Don't know
Aye.
if I need to ask them for a favor or not.
Goodbye.
Thank you, everyone. Thank you, Sally. Anything else you'd like me to sign?